Well, as your lordships has heard the trend of my arguments yesterday.
Yes.
Your lordship knows the angularities, if I may say so, and the pointed thrust of it. It is not a perfect world in the world in which we are projecting. We respectfully agree and bow down that there are angularities. But for a matter like this, my only submission is that these are angularities which your lordship have in the past surmounted and should and can do it in this case. So I am not projecting a perfect world. Number two, we had done with the three options which your lordships finished in para 14, just above 15. Since your lordship has a view about notice and objections, almost 1/3 of my written submissions are notice and objections. So therefore, very little is left now. Let me go to para 15. My submissions, my lord has got. Each of my lords.
It would not follow.
Yes. Justice Kohli, Justice Paul has got it.
Yes. You're looking to your rejoinder submissions.
Yes, yes.
Which paragraph?
15, 1-5.
Yeah.
Yes, my lord Justice Paul doesn't have it.
The rejoinder submissions likha hai.
Yeah, likha hai.
It starts with it would not follow from.
It will not. Correct. So the conclusion after the three options is.
Look for it. I haven't. Documents by Dr. Singhvi. Please start.
Yes, Dr. Singhvi.
15. It would not follow from this approach that non-heterosexual Hindu couples who marry under SMA would be excluded from legal succession regimes altogether. Like non-Hindu interfaith couples, they are governed by the ISA. This is because 21A on its own terms assumes that marriages that it applies to are also capable of being valid under HSA. Last 4 lines is the conclusion. Till the right of non-heterosexual couples to marry under HMA is adjudicated upon by this court or provided for by the legislature, non-heterosexual marriages simply do not meet the preconditions for the triggering of 21A. This is the exclusion of 21A, which was my third option. I'm actually, if at all I'm forced to, I'd canvass the second option, but I'm completing on the third option. Each are your lordship's choice, but the second option would be one thing which your lordship may see. Now I come to 2 or 3 special cases and I'm done very quickly. One is this heteronormative settings. That is a separate, discrete head. Kindly bear with me just for a few minutes in that. Women in particular, in heteronormative setting. Well, just before I read it, one sentence. We, on this side, me, is challenging only the exclusionary provisions. The whole thrust is exclusionary provisions, namely, those which discriminate against me based on my ascriptive characteristics. Now read my para. In a nutshell, this subheading contends that several provisions of the SMA which attempt to create a protective arc for women in a heterosexual marriage, treating them as structurally the more vulnerable gender. In the old days, we used to call it the weaker sex, but that's not quite a correct word. Need not be interpreted in favor of either partner in a non-heterosexual marriage, which proceeds according to a gender-neutral approach. The stand of the petitioners fully answers and takes care of the respondents' wrongful contention that a gender-neutral approach to SMA defeats the purpose of certain provisions which are enacted to counter unique gendered situations. Example, rape, sexual violence. If the aforesaid gender-neutral approach of the petitioners, eschewing the sections dealing with preferential protective treatment of women under the SMA is accepted, the diverse contentions of the respondents, the other side, example those relating to section 27, would not arise. In that sense, this set of submissions by the respondents is either a red herring or attempts to set up a straw man in the name of the petitioners and then triumphantly shoot it down. Petitioners submit that these grounds and sections of the SMA, which deal with important gendered and heterosexual settings, namely the more vulnerable woman partner protection provisions and legal protections, are not part of their prayer for marriage equality. The petitioners are not seeking interpretation of every gendered word in the SMA in a gender neutral way. We are only assailing those parts of the SMA that require a constitution compliant reading on grounds of discrimination and exclusion of non heterosexual couples. It is you who are putting this in my mouth and say there is insuperable problem for the judges. I am not concerned with protective clauses in or one-sided clauses like rape, etc., which will necessarily apply in a heteronormative setting. Hence, the focus of interpretation similarly has to be on the discriminatory aspects of the Act that are relevant to and exclude non-heterosexual couples. I'm on exclusion only. Those provisions that specifically deal with heteronormative settings and offer rights protections to women, queer men, do not require a constitutionally compliant interpretation. So you are putting it into my mouth and then saying judges cannot do it, it's impossible, etc., etc. It is crucial to clarify that this is not a case of anomalous cherry picking. I'm just giving a few lines. Justice Bhatt also raised it when I had opened this quite rightly. It is not a case of cherry picking different interpretive regimes for the same words within the same statute. I'm addressing your Lordship in para 19. Returning to the issue of the underlying thrust of legislation and a constitution compliant reading, when it comes to the use of gendered terms to specifically address gendered imbalances of power, physical, normative, and therefore achieve substantive equality, limiting such terms to their gendered heterosexual context is consistent with the law's underlying thrust. So don't put in my mouth that I'm challenging it and then say that you can't challenge it. I don't need to and I'm not. It can therefore be seen that the petitioner's approach is entirely consistent with my two anchoring points. My anchors are twofold. One being the underlying thrust of the SMA, which already exists as a secular platform for non-personal law couples mostly, and the fundamental rights in the Constitution is the other anchoring point. In other words, it is permissible for the specific interpretation of different gender terms across the SMA to be interpreted with a view to ensuring that their interpretation serves the underlying thrust of the SMA and the principles of non-discrimination and equality. Therefore, my conclusion was para 21. Hence, this Honorable Court may declare that provisions of SMA with respect to solemnization and registration of marriage are extended to non-heterosexual couples, except to the extent that provisions of the SMA or any other law in force are enacted for a wife against husband in a heterosexual marriage or for a woman against a man in a gender-specific context. That is basically the rape category, the sexual violence category. A list of such provisions clearly, I have given in Annexure 2, which is at page 27, a whole list of such provisions for your lordships, but I have culled them out just for ease of reference. No. Interaction with other laws that include matrimonial rights. This is another category, very small category. Respondents' other also argument that the bundle of allied rights that accompany marriage cannot be addressed by this court, as they involve multiple legislation and complications. Petitioners disagree. A valid marriage in the eyes of law is like an index or key to other secular matrimonial and family laws. The current scheme holds that only a man and woman married under the Act can qualify as a legally married couple, entitling them to benefits under other statutes that require marriage status. Statutes that use the gender-neutral word spouse require no further changes. Rights under these statutes will naturally flow if the Supreme Court interprets spouse to include some gender and queer partners under SMA. This is a separate list, Annexure 3, at page 30 of my note. You should note the page there, at page 30. This is that category where your lordship has to only hold that spouse includes a queer couple, but not that your lordship will say that wife includes spouse or husband includes spouse. Statutes that use gendered words like husband and wife may be interpreted in gender-neutral way as persons, consistent with the interpretation for marriage equality. Hereby clarified that the present set of petitioners have limited submissions specifically to the issues arising from the SMA and on succession issues limited to the ISA. That is my option 2 really. And are not seeking this honorable court's interpretation for the diverse list of acts that use gendered words which may be reserved for future interpretation. It is further submitted not open to the respondents to argue that the petitioner's fundamental rights may not be recognized simply because it will open the pathway to further litigation, seeking the full and equal import of the rights that may be recognized here. The forward march of the law and of fundamental freedom has been based on litigation such as these, and the recognition of fundamental rights of citizens cannot be held hostage to the false virtue of preventing further litigation. The directions the Lordship issued in Malas Navtej, have they been complied with by less than legislation? Your Lordship required less than legislation there. And you are told that legislation will solve all our problems now, Malas. Your Lordship required something very minor compared to, in my opinion, under that. Has it happened? Then age related. I must be consistent with I'll make Malas. Again, please keep the perfect solution is never there. I think it's a good solution we are trying to offer. I'm not suggesting it is fully logically consistent, but it's a workable solution. Kindly see this. On 4C, Malas, same-sex couples, the provision may be read as prescribing 18 for both parties in a lesbian relationship and 21 for both in a gay relationship. In the case of transgender, so there are only two categories, lesbians or homosexuals, there will be 18 and 21, which ages your Lordship already has in the Act. In the case of transgender, this is on the graded hierarchy of LGBTQII++. Whichever gender sex they identify as, the concerned age requirement would apply. That is, a trans man would have to be subject to 21 and a trans woman would be at 18. Because the whole point of that II and plus plus is that they have to declare themselves as a woman or a man. Then, Malas, the approach in the previous paragraph leaves open the question of age qualification for persons seeking to marry who do not identify as either man or woman. Now, Malas, I'm giving your Lordship a theoretical category, but yes, it is a category. It's a very small category, but I'm still, Malas, giving it because I don't want to avoid it. Petitioners suggest that the following alternative routes of interpretation may be adopted to ensure inclusion of non-binary and intersex individuals. It's a small category. It should not defeat my entire case. It's largely a theoretical category, but please see the solution. First, the SMA's silence on the age of qualification for persons other than men or women may be read as imposing no restriction beyond that imposed by other laws that stipulate the age at which the persons became capable. In other words, this category, universal 18. In one word, I'll skip the paragraph. 18, which is your Lordship's age of consent for 99%.9. Now, civil union, I'm done. That's the last point. Well, with great respect, civil union at para 29 is no solution. I'll explain in 2 minutes. Fellows. Civil union is not a solution, not an equal alternative. Third line in 29. Petitioners respectfully submit that civil unions do not address the constitutional anomaly presented by exclusion of non-heterosexual couples from the legal and social institution of marriage. A civil union is not a marriage. It is both the marriage as an access to marriage and equality in marriage that we are seeking. Now, just see this rather interesting case from Supreme Court of New Jersey. In that case, Lewis and Harris, this is directly going to be relevant. Third line. The state's marriage laws excluded non-heterosexual couples like today. The majority held such laws to be unconstitutional. So your Lordship struck down those laws. But remedy your Lordship gave was civil union, to be remedied either by amendment or by creation of a separate civil union status for queer couples. Well, as Chief Justice Porritz, with the other 2 judges, dissented. And this dissent later on became the majority view in the US. I'll read the dissent very briefly. We must not underestimate the power of language. Labels set apart people as surely as physical separation on a bus. This is going to be important, Malas, on a bus or in school facilities. Labels are used to perpetuate prejudice about differences that in this case are embedded in the law. By excluding same-sex couples from civil marriage, the state declares that it is legitimate to differentiate between their commitments and the commitments of heterosexual couples. Ultimately, the message is that what same-sex couples have is not as important or as significant as real marriage, that such lesser relationships cannot have the name of marriage. Whereas Oberfell, which accepted it, did not cite Chief Justice Porritt's, but whereas it adopted this view, which I have quoted. The original source was whereas the dissent has become the prevailing one in para 31. It has been held that equal protection required marriage. Indeed, any other view would militate against India's own jurisprudence on substantive equality. Relegating non-heterosexual relationships to civil unions and denying their access to the marital institution would send those in such relationships a clear message of subordination, that their relationship is less than, quoted, inferior to relationships that comply with the entrenched heteronormative order. Petitioners' relationships do not deserve the name of marriage. By doing so, civil union status would undermine full and equal. It's full is one word, equal is the other. Social, economic, political, and cultural participation and contribute to the petitioner's subordination. One is my last point. I may be perhaps guilty of slight exaggeration, but I think it's an appropriate analogy. The segregation doctrine of separate but equal is what I've said in the last para 33. A civil union says, yes, you are equal, but you are equal in that side of the table, within your separate enclave. And within this sector, my enclave, this is a different equality. This separate but equal, your lordship, is frowned upon. In all civil rights issues, this should not be a new creation judicially. But as I am ended, your lordship may reconsider. If your lordship feels para 34 onwards is a strong argument for notice and objection, I am not arguing it.
Right.
I am not arguing.
Thank you, Dr. Singhvi.
Don't do my submission.
Thank you, Dr. Singhvi.
I am very deeply obliged.
Thank you, Mr. Dr. Singhvi.